Hey everyone, welcome to another week of KNR 462. This week's module is going to set off a 2-week unit over constitutional law. So we're going to spend the next 2 weeks talking about this area of law, which is a lot. There's a lot there. So we're going to highlight a few specific areas of the U.S. Constitution that impact or apply to what we do in the sport industry. And today, and really this week, our focus will be just providing an overview of constitutional law, what it means in this country, and then specifically defining this concept of state action and essentially how we determine which sport organizations can actually be sued under constitutional law. And then part 2 of the module will focus on the first specific area of constitutional law, due process. Okay, so quick flashback to one of our early lessons in here where we identified these various sources of law in the US. And if you remember, one of those primary sources of law is constitutional law, right? So we already have identified this as being an integral area of law in this country, and we define constitutional law as laws that are inherent in the Constitution. Wanted to dig a little bit deeper into that definition here before we get into the concept of state action and due process. So let's do just like a very quick background here of the U.S. Constitution. I know we've all probably had some kind of civics lesson on this, and certainly the Constitution is a topic constantly in our news cycle. So I know we all have some familiarity with it, but I just wanted to go over a couple of key concepts that I think are important for us to understand before we can fully understand how the Constitution impacts the sport industry. So first and foremost, we're going to focus on the U.S. Constitution in our class. As I think we discussed earlier in the semester, constitutional law contains both the federal constitution and state constitutions. So each state has its own constitution. We're going to focus on the U.S. Constitution, the federal constitution, because it certainly has the most impact. So very brief history lesson here. We know the Constitution is ratified in 1787. This is a result of the Revolutionary War ending, and essentially the U.S. is created, right, out of that war. We have gained our freedom from England through that war, and therefore now we're setting up our own government and our own system of governing. So that's really the precipice for the U.S. Constitution. And if we think about the reason it's created and the timing of which it's created, it makes a little bit more sense as to why it's written the way it is. Keep in mind, the Constitution is not in place to govern individuals, right? The Constitution is in place to govern governments, right? Because if we think back to the Revolutionary War, the U.S. at this time, or the colonists, have essentially fought back against England because they wanted their own way of governing, right? They no longer wanted to be under British rule. So it makes sense that when they're setting up their own government here in the U.S., that they decide, okay, we're going to create a system in which government can never have too much control over its people, okay? Hence the U.S. Constitution, this, very influential legal document that we now have. So the Constitution not only sets up the form of government and structure of government, but some fundamental laws that it thinks are very important in just basically creating our legal system. So again, the U.S. Constitution is not in place to govern individuals or private entities. It's in place to govern governments. It's in place so that the U.S. citizens do not experience any kind of infringement by the government. So for me, the way I think of it as the U.S. Constitution governs governments, right? And that's what its key purpose is. Okay, so when we think about kind of the purpose of the U.S. Constitution and how it folds into what we do in the sport industry, I always think it's important to think about this as sort of a balancing act that the courts have to do. And this chart or this table that I'm showing you right now is going to come up again throughout our lessons here on constitutional law, because I think ultimately when a court is looking at a constitutional law claim or case, they're having to do this tricky balancing act of, one, identifying that a sport organization has its own rights to come up with policies and rules. They have that right, as an entity. So on one hand, the court has to acknowledge that the sport organization has its own authority to govern internally. But on the other side of that scale is individual citizens' rights under the Constitution, right? So it's up to courts to balance these two things, right? On one hand, to give sport organizations enough freedom so that they can come up with their own policies and rules and decisions, but also understand that we don't want those sport organizations interfering in individuals' rights, right? So this is the balance that the courts are having to make. And honestly, what they're looking for are instances where the policies or the procedures in place by a sport organization are no longer fair or reasonable, right? They cross the line into being unfair, unreasonable, and therefore have an impact on an individual's rights. And that's when the courts get involved. All right, so you might be thinking, what does this have to do with sport, right? What does constitutional law have to do with the sport industry? Well, there are several aspects of the U.S. Constitution that do impact the sport industry, or rather where we have, history of cases that were filed under these areas of the Constitution. So I'm highlighting this list here, and obviously we're going to get into detail on more of these topics over the course of the next few weeks. Today, for instance, or this week, we're going to focus on this concept of due process. Next week, we will highlight the concept of equal protection under the laws, specifically this issue of discrimination. We'll also spend some time looking at the First Amendment and the various freedoms under that and how that impacts the sport industry. And then another area where we've seen historically the Constitution and the sport industry collide is through drug testing and this question of privacy. So all of these things are, examples of where the U.S. Constitution and the sport industry collide in some kind of conflict. And it's, even though this document is hundreds of years old itself, the law itself is fluid and evolves over time in terms of its meaning. So it is interesting to see how even some of these cases that were decided maybe 30, 40 years ago are changing, or simply how technology has changed some of these things. So you might be asking which areas or which sectors of the sport industry are most impacted by the Constitution. And if you weren't, now you are, right? So just to give you an idea here of which areas are most impacted, just put together a series of headlines here, right, where we see news clippings of cases involving the U.S. Constitution and sport organizations. And if you kind of just do a cursory review here of some of these headlines, you probably see that most of these cases are involving either high school athletics or college athletics. You don't really see any headlines involving professional sports teams or private sport organizations. And the reason for that is that professional sports are way less likely to be involved in constitutional law cases due to the private nature of their business. And we're going to define this concept of state action here on the next few slides, so it should make more sense. But just keep in mind that certainly the areas of high school sports, college sports, park districts, really any kind of sport organization that has some kind of tie to a government entity or is itself a government entity is certainly going to be under scrutiny regarding constitutional law in a way that professional sport organizations are simply not due to their private nature. Okay, so speaking of this concept of state action, if you take nothing away from this week's module, I would be a little concerned. But if you take nothing else away, I hope that it's this concept of state action, because this one's going to be very important for you to understand, not just for this week's module, but for next week's module as well. Because all constitutional law claims in this country are centered around this question of state action. Meaning that in order for a U.S. constitutional law claim to move forward in our court system, then the party or organization that is being sued has to be classified as a state actor. If there is no state action on the part of the on the part of the defendant in a case, then there is no constitutional law claim. You have to be able to prove state action in order to pursue a constitutional law claim. So we've already sort of hinted at this concept of state action and who might be a state actor. I just want us to break down the definition here in a little bit more detail. So you can see here, a state actor is defined as a person who is acting on behalf of a state, local, or federal government body and is therefore subject to regulation under the U.S. Constitution. Remember back to the very first or second slide that I showed you, right, where I said the purpose of constitutional law is not to govern individuals, not to govern private citizens, but to govern governments, right, to keep government organizations or individuals from pursuing the rights or infringing on the rights of citizens in the U.S. So therefore, it makes sense that in order to sue someone under constitutional law, you have to be able to prove they're a state actor, right? Otherwise, the case isn't relevant because the Constitution is only applying to state actors. All right, so to test your understanding of this concept of state action, I want you to go ahead and pause the video and take a few minutes here and run through this list of organizations. And I want you to check the ones that you think would be obvious state actors within our field, within the sport industry. So go ahead and pause, and then once you've had a chance to run through them all, come back to the video and we will review them. Okay, so let's see how you did. So we'll just go through these in order. So a public grade school or high school is considered to be a state actor, right? A public high school, for instance, is a high school that is essentially governed by the state, right? They get funding from the state. Their policies are predicated by state policy. They are considered a government actor or acting on behalf of the state government. So yes, they would be classified as a state actor. Same is true for public universities and colleges, right? They are also getting funding directly from the state, making policy based on state policy. They're essentially a state actor. So public university like Illinois State is in fact a state actor. Myself and Becky Aiken, for instance, as faculty members and employees of public university are also considered state actors, right? We're acting on behalf of a government entity. Private university or college, say like Wesleyan, that some of you work at, is not considered a state actor, right? It is a private university and therefore not classified as a state actor. A public recreation facility or department, yes, also a state actor, right? This is a local agency that is getting direct funding from the local municipality and is essentially tied to that local government, therefore a state actor. I'll go through these two together. A private fitness facility, not a state actor. Private rehabilitation center or medical facility, not a state actor, right? You're probably getting the hint here, right? Anytime you see the word private, we are not referring to a state actor, and therefore those organizations could not be sued under the Constitution. There's some gray area here. So some organizations in our field that may or may not be clear-cut state actors, but could be in some instances. So first is College Athletic Conference. So typically these are viewed as state actors, and historically they have been classified as state actors. But typically what will happen is the court will look at the schools within the conference and sort of assess what the mix is in terms of public universities versus private universities. So for instance, like the Big Ten has a lot of public universities in it. The majority of schools in a conference are public schools, then it is likely going to be classified as a state actor, the conference office. But if the reverse were true, if it were primarily private universities that were making up that conference, it could go the other way. It could be classified as a non-state actor. Professional sports teams and leagues. This one is also another gray area. Historically, professional sports organizations in the U.S. have not been classified as state actors, right? Think about the business model. These are individuals or families that privately own a team. There's generally no tie to a government in that scenario, right? It's a private business model. So usually the answer is no. But there have been some instances where a professional team has been classified as a state actor. A case that we're going to look at in more detail next week when we get into our unit on equal protection is Ludky versus Kuhn, which was a lawsuit involving the Constitution and the New York Yankees, essentially a female reporter filing a lawsuit against the team and Major League Baseball because she wasn't given access to the locker room. This is back in the 70s. So essentially, in that case, the court determined that the Yankees could be deemed a state actor in that case because the facility in which they played their games was primarily funded by public dollars. Okay. So there have been some unique situations like that where a professional sports team has been deemed a state actor because of the widespread public financing that they received to build their facility. But generally speaking, sport organizations are not classified as state actors. All right, our last one here, high school athletic associations. So this one is also a gray area. So similar to college athletic conferences, it's possible a court could determine a high school athletic association like the IHSA as being a state actor if they find that they have enough of an entanglement or connection with public schools within the state. But if they find their membership is largely private schools, then they probably would not. And I'm going to share an article about a recent case involving the IHSA and this question of whether or not they're state actors in your ReggieNet module this week. So be sure to check that out. And we're going to get into that question a little bit more here on the next few slides as we think about other ways. Typically, private sport organizations might be classified as state actors in unique scenarios. But one thing I would add to this conversation as we're thinking about what organizations are classified as state actors and which are not is just think about your current role, whether that's as a full-time employee for a sport organization or a GA in one of the athletic departments here locally. Think about where that organization falls in this chart and whether or not you personally would be deemed a state actor based on that classification. And that might change your perspective as we review the various topics in constitutional law here over the next few weeks. And also keep in mind that your role might change, right? You might go on to work for an organization that is currently a state actor, and maybe you're not currently doing that. So important to keep in mind all these various sectors and how they are viewed through this lens of state action. Okay, so I mentioned previously that there are some ways that we can classify sport organizations that we would traditionally deem as private to state action or state actors. And these are situational. So keep in mind that a sport organization might be classified as a state actor in a particular situation, particular case. That doesn't mean that they will forever be classified as a state actor. It may just be a situational thing. But it's important to understand these two theories that will potentially allow a sport organization to be classified as a state actor. So let's just take these one by one. This first one is this Nexus entanglement theory. This theory essentially states that when a state's involvement or entanglement with a private sport organization is sufficient, then the private actor, the private organization, can then be classified as a state actor. So typically private sport organization has, essentially this ongoing relationship with public entities, and therefore their entanglement with those public entities means that we can classify them as a state actor. So I use the IHSA as an example, and this could, go for other state high school athletic associations as well. If we were to look at the membership of the schools in the IHSA and how many state schools are actually public that are part of that membership, we would see that the majority of schools are actually public. So you could certainly argue that because the majority of schools that the IHSA works with when coordinating, planning, putting on these championship events, if the majority of those organizations are public, then you can certainly argue that they have this entanglement, this ongoing relationship or entanglement with state actors, and thus could potentially be classified as a state actor through this entanglement theory. This other theory, the public function theory, essentially states that if a private party or private organization undertakes functions or assumes powers that the government or a state actor would typically perform, then that organization could be classified as a state actor. So an example I use is, say, a privately owned arena hosts high school athletic events, right? So it's like a private facility that is private ownership, but they take on this role of hosting an event that would typically be hosted by some kind of public or state organization. Therefore, by assuming those functions, we could potentially classify them as a state actor in that situation. So yeah, there are ways in which what we would deem typically to be private sport organizations could be classified as state actors, even if they don't meet our sort of traditional definition of what is a state actor. And like I said, I'm going to share an article about the IHSA and this kind of ongoing debate they've had about whether or not they are indeed a state actor. And I think it's a really interesting one to consider, and it's a local case for us to look at. So make sure you take a look at that at some point. All right, another pretty major party in our field that I think we need to talk about in terms of whether or not they're classified as a state actor is the NCAA. And this one has a very interesting history. And you can see here, basically, I've given you a rundown of all the court cases that have assessed whether or not the NCAA is actually a state actor. And you can see by looking at this history here that courts can't really make up their mind about how they feel regarding the NCAA status as a state actor. You can see that some of these early cases in the 70s, the courts were classifying the NCAA as a state actor, meaning that they could be sued in these cases involving constitutional claims. And you can see some of the issues at stake here. But then you see in the 80s, there's a shift, right? And we see basically 4 cases in a row that classify the NCAA as not being a state actor. So we see a major shift there, which, ultimately provides the NCAA with quite a bit of coverage, right? Because these cases ultimately create this new precedent where other courts are not willing to review constitutional law claims against the NCAA. So those claims those cases are pretty prominent in terms of their impact, especially in the 90s and early 2000s. But then you can see here a more recent case, this 2014 case involving a coach firing, where the court ultimately did find that the NCAA was a state actor in that scenario. So, it's still sort of up for debate. And like I said, some of these are situational. So it'll be interesting to kind of follow from here on out if we start to see more cases looking at the NCAA as a state actor, because it would certainly open up the playing field a bit in terms of whether or not athletes or coaches are able to file claims directly against the NCAA.